If you co-own a small business in Alberta and you're in a prolonged dispute with your co-owner, you may be looking for a quick and easy way to end this fight. One of the best ways to do this is through exercising your shotgun clause. But if you have a shotgun clause, you may be wondering how to do this. I'm Mike with Cashion Legal, and in this video, I'm going to cover the topic of shotgun clauses in business ownership contracts. At the end of this video, you'll have a better understanding about how shotgun clauses work and what are some of the legal risks involved with triggering your shotgun clause. I will also provide you with some practical tips that you need to consider before you trigger your shotgun clause. And if at the end of this video you're still looking for further clarity, you can always contact our office for guidance on these issues. So let's start by explaining the basic mechanisms associated with a shotgun clause. A shotgun clause is a buy-sell mechanism that is built into any co-ownership agreement. You can find shotgun clauses in shareholder agreements, partnership agreements, or really any agreement that formalizes the business relationship between two or more parties. The intention of a shotgun clause is to give the co-owners a quick way to end the business relationship if things start to fall apart. In its most basic form, a basic shotgun clause will stipulate that one party can buy the other party's interest at a price of its choosing. Effectively, this party says to the other party, I don't think we should work together anymore, and here's what I'm willing to pay you for your interest in the company. Then the other party usually has an option under the shotgun clause. They can do one of two things: agree to sell their interest to the other party or offer to buy the other party's interest at that same price. The key feature is that the party who determines the price by making the initial offer does not get to choose which side of the deal they end up on. This creates a strong incentive to present a fair offer because a lowball offer can easily backfire. And the true beauty of a well-designed shotgun clause is that it avoids a prolonged dispute about the valuation of the business. In the absence of a shotgun clause, litigation can take years in order to resolve a number of different issues, including who gets to buy and who gets to sell, and what the value of the company should be. So a properly exercised shotgun clause can facilitate the orderly exit of one owner from the business. So now that we understand some of the basic mechanisms associated with shotgun clauses, let's talk about how the courts view these contractual provisions. The Alberta courts take a very strict approach when it comes to enforcing a shotgun clause. In fact, one court described it as a strong medicine, which must be taken strictly in accordance with the prescription or not at all. What this means is that the offer under a shotgun clause must comply exactly with the terms of the contract in order to be enforced. Even the smallest error could invalidate the offer under the shotgun clause, so it's important to adhere exactly to the terms when you're exercising this type of term of the contract. Another thing that the courts have made clear is that shotgun clause offers are generally irrevocable. This means that you cannot test the waters by making an offer and then pulling it back if you don't like the response. The courts have been clear that allowing parties to revoke the clause would defeat the purpose of the mechanism. Put another way, a shotgun clause is not a negotiating tool. It is an instrument that should only be used to actually end the business relationship between the co-owners. So with some of those basic legal principles established, let's talk about some of the practical considerations of exercising your shotgun clause. Practical consideration number one is financing. Before you exercise your shotgun clause, you should be clear about how the money to purchase the shares can be provided. For example, if the terms of the shotgun clause require you to deliver all cash by a certain date, it would be worthwhile to make sure that you have enough money to make the purchase before you make the offer. In these situations, if you don't have enough capital on your own, you should line up a source of funding before triggering the clause. The second practical consideration you should keep in mind when exercising your shotgun clause is the value of the business. As I explained earlier, the inherent mechanism of the shotgun clause is designed to create fair offers from one party to another. If you make a lowball offer to the other party, you can reasonably expect that they will try to purchase your interest in the business for that favorable price. Conversely, if you feel like your other co-owner really wants to keep control of the business, so you artificially inflate the value of the company with the expectation that they're actually going to purchase, this can also backfire. Because the shotgun clause is generally not revocable, you may end up having to buy their interest at this inflated price. For that reason, it's best practice to choose a value that is fair and one that you can live with on either side of the equation. The third practical consideration to keep in mind is the timing provisions of the shotgun clause. Shotgun clauses often have strict deadlines about when things need to occur. It's important to be mindful of these deadlines and to adhere to them in order to properly enforce your shotgun clause. Fourthly and finally, you should inform yourself of the tax consequences of triggering your shotgun clause. We always encourage people to seek tax advice from an accountant when they're triggering the sale of their interest in a business. Getting this advice early on is important because it will have implications on what strategy you're willing to pursue. The bottom line is that shotgun clauses can be an efficient mechanism for ending a bad business relationship. However, properly triggering a shotgun clause means that you strictly adhere to the terms of the clause and you do so with a strategy that works for you. Our team provides small business owners who are looking to end their relationship with a co-owner by providing them with clarity about their options, strategies for navigating the situation, and peace of mind through sound advice and strong representation. If the content of this video is applicable to your small business and you're looking for assistance, you can connect with the team at Cashion Legal by clicking the link to our website in the description to this video.